Perfect. Okay, so welcome everybody. This is the second webinar we've done in our expert series, first of 2022. We're super excited. Estate plans, the gift that keeps on giving. So we are Hillside Wealth Management, and we have our fantastic guest, Steve Parr, who's part of Parr Business Law. Very, very excited to have him here today. And we are going to be talking about everything estate planning. Okay, so what we're going to cover, we'll give you a brief overview of Hillside Wealth Management, and then we're going to let Steve give you an overview of Parr Business Law. We're going to go through wills, estates, everything you need to know in between on a high level, right? So if you have specific questions, again, chat, Q&A, please feel free to put them in. Let's get corporate. Some of you have corporations out there, so we'll touch on that. And everybody's favorite topic, family drama, right? Show me a family without drama, and I'll eat my words. All right, so Hillside Wealth. We have a fantastic division of labor over here at Hillside Wealth. We've got the portfolio management side, which encompasses Jason and Steven. And then we've got the client-facing retirement planning side, which is myself and Mike. And then the three fantastic ladies that keep the show running are Heidi, Rosita, and Sabrina. We couldn't do what we do without them. And in terms of our general overall values, we've got freedom, family, and performance. So those are three criteria that are really, really important to us. Freedom to be able to do what you want, to live your life, have fun. Family is big. I think everybody now at Hillside has a family, is intergenerational at this point, pretty much, which is awesome. And we like to consider our clients as part of our Hillside family as well. So when we say family, we're not just talking about our own, but that's you as well out there. You're included in our family. And performance. We have a very strong tie to performance. We want to exceptionally do well consistently. So yeah, those are our kind of three big values. I know they're really important to Mike as well. So Mike, anything you want to add on those?
Yeah, I mean, I think the performance, both the big thing with these two things is they're reciprocal. Hillside needs the freedom to be able to do exactly what we feel is best for our clients with no other, management or corporate agendas from head office. And that gives our clients the freedom to do whatever it is that they want to do their very best, right? From a family perspective, obviously Hillside, we treat our people like family. We are family, Jason and I being brothers-in-law, and we work with families. And then performance. Yeah, we want to perform so you can perform. And that's really the way we set this up. Performance, freedom, family mean the world to us. And yeah, we're all about that. As you can see, here we are in 3 different locations having a webinar on estate planning at the end of our SP season, while the markets had an interesting day. So we do have the freedom to talk about what we choose to talk about as well, which is good.
Yeah, awesome. And so I'm going to let Steve take over from here, introduce himself, introduce Parr Business Law and his team.
Hey, everybody. So I started a law firm, Parr Business Law, started in 2017, so just over 5 years ago now. So prior to that, I had owned and operated a small vacation rental management company in Vancouver and Whistler. And that was really what produced the segue into business law, because I worked with advisors, worked with lawyers, accountants, a variety of different professions, and it was tough. It was tough to find good people. It was tough to find a good match, and it cost a lot of time and headache and hassle and all that stuff. So I knew that there was a spot there for me to help, and I knew what it was like to be an entrepreneur on the other side of things. So Parr Business Law, what we do, we basically target business owners and their families. So business owners, primarily small business, anywhere from just getting started up to 10 million in revenue a year and beyond. And then we provide estate planning services. So that means wills, power of attorneys, representation agreements, and a bunch of other things that we'll get into later in the presentation. So yeah, on the corporate side, like we do everything: shareholders agreements, all different manners of different types of business agreements. We do a little bit of a dispute resolution as well. I'm very, very community oriented, and that's one of the things that has enabled my firm to really thrive, is because of the strength of my relationships, like with Mike and Amanda here, for example. And so to that end, I also founded a small network of Vancouver small firm lawyers. And yeah, and I love the outdoors. So we were just talking about cold plunging at the start of the call. So big on everything that Vancouver has to offer, and love to travel as well.
Yeah, and just a quick story, Steve, about how I came across you. I was sort of, I guess, you know, catching up on family trusts and different things, and making sure I was up to speed on everything that was going on. And here was this, you know, a lawyer on YouTube talking about, you know, why a family trust or why a holding company or why this or why that. I thought, hey, good for him. I'm going to reach out. We reached out, and here we are today. So really happy to have you here, Steve. Thanks so much for jumping on the call. And we definitely get a lot of questions about estate planning. I do have my certificate in advanced trust and estate planning, but that's just, I look at that as like a certificate to know that I know just enough to know that we need to know more, right? So I'm really happy to have you here, and looking forward to having a great conversation. So thanks.
Yeah, and you have a growing team as well, I think, Steve, right? Your team is growing. It's not just you, which is important to note.
Sure, that's right. Yeah, so I have an associate lawyer named Ty, and then there's the rest of the operations team here as well. Amrinder is an articling student with us. He'll soon be a lawyer as well. So yeah, it's been a really good year. I think COVID was good to us for whatever reason. So yeah, the team is certainly growing quite a bit right now.
Awesome. Perfect. Well, we're going to jump right into it. So first up, wills and the estate process. And we had a little bit of fun with this slide. So I'm not sure if this like ages me at all, but if you're not familiar, this is from the movie Napoleon Dynamite. It's a great movie. Steve and I have both seen it. We don't really know if Mike has, but it's a funny movie. He doesn't actually talk about estate planning in it, but this GIF I found and thought it was pretty great and very much real. I just signed my estate plan.
So Amanda, you didn't date yourself by knowing that it was Napoleon Dynamite, but you did date yourself by referring to that as a GIF. That's a meme. It's just an image.
There you go. Okay.
There we go. So let's talk about things getting serious and doing.
Let's talk about wills. So yeah. So why get a will? I mean, we are just going to kick this presentation off with like the most 101 piece. Who needs a will? Why do you need a will? So basically, I say that anybody who is above the age of majority needs a will, and then there are
age of majority in BC is
age of majority is 19 in BC.
Okay.
And yeah, I mean, really, you need to get a will. It's very important that you have a will, of course, when you have assets and when you have children. It's absolutely essential in those cases. So yeah, sorry, Mike, I just jumped in, but did you want to sort of like?
No, that's good.
Like
and I think I just think it's important for everyone to know too that I think there's some stat out there, 34% of Canadians, only 34% of Canadians have wills. There are many people that we come across who are, you know, in their 60s, Steve, worth, I would say, millions of dollars, millions and millions of dollars, that don't have a will. And we have some clients who still don't have a will, even though that we've talked about them getting one for many years, and they just don't see the point. So I think just a big, what happens if we don't? Like, what happens if we die without a will would be a good point to cover.
One thing to note on the statistics, the good thing, so Quebec and BC have the highest number of people with wills. It's still only at about 50%. So if you're in BC or Quebec and you have a will, congratulations, you're part of the majority. But Mike is right. Overall, Canadians, it's about 34%. So there you go.
Okay, right on. So yeah, what happens if you don't have a will is that if you don't have a will, then you lose control over how your assets are distributed. So let's just take like an example. Say like it's a person who is unlikely to get a will. So a younger person, say they're 25 years old, they've got, they've done relatively well and they have $50,000 of savings. So if they die without a will, then their next of kin, even if this person doesn't have a spouse, doesn't have any kids, so the person, their parents are going to have to apply for what's called an estate grant. So there are two types of estate grants. And I'm not sure if my mic just went off. 1 sec.
Yeah, your volume changed a little bit, but we can still hear you.
My AirPods just kicked in.
Oh, there you go.
Anyways, what happens in that circumstance is that, yeah, their parents are going to have to apply for a grant of administration. And a grant of administration, it's a long drawn out process. It involves applying to court, applying to the probate registry, and it's more complex than getting the alternative, which is a grant of probate. So if you have a will, you get a grant of probate. If you do not have a will, then you're going to get a grant of administration. The only circumstance where you don't need both those things, either of those things, a grant of probate or a grant of administration, is if your total assets are less than $25,000. So
Okay.
that's sort of the threshold there. And so more to the point, it's like, in addition to this being a bigger pain, more time consuming and more expensive to get a grant of administration, it's also creates a lot of confusion, because then you don't know where the assets are going to go, and the assets are going to be distributed according to what's called Intestacy Rules. So Intestacy Rules are a part of WESA, which is the Wills, Estates, Succession Act of BC. And that basically means that the government has its own distribution scheme. So, and that may or may not be consistent with what the person wanted. So.
Yeah, and I think that's the big message, right? Is that, you know, as you accumulate assets in life, and you want to be able to, you know, decide where those assets go, whether it be to charities, whether it be to certain family members. And I think what we see is, you know, people are living in the moment, trying to, you know, grow their business or graduate from medical school or whatever it is, and they lose sight of the fact that this is actually a thing that needs to be done. And so what we want to do today is just kind of lay it out. It's actually not that complicated to get one. There's a few big decisions that need to be made, especially when kids are involved, which we'll talk about. But the nuts and bolts of it are that a will certainly make sure that your assets go to where you want them to go, and it'll smooth the process out. And the big thing as well is, you know, let's assume, Steve, even that you know, a person has a family that they love dearly, and that they love them exactly the way that the government says that they should love them and hands the money out accordingly. That's still a complicated process to do, and it could go awry if it's not done without a will. So we just see no reason for them not to get it, essentially.
Yeah, I mean, obviously the loss of a loved one is a terrible situation, you know, no matter how you slice it, and it just adds insult to injury, essentially. You know, like it's going to prolong the process, and the last thing you need to be dealing with is you know, wading your way through a complicated estate when
Emotions are running high.
Hey, emotions should be dealt with, you know. So
yeah. One of the things, and like, if we can, let's talk about probate, Steve, just for a little bit, because probate gets a bad rap in a lot of ways from the media, and you know, just in general, we hear a lot about people trying to avoid probate. So why don't we just take a minute, and if you can just explain what probate is and how it works, and we can talk a little bit about the costs involved there as well.
Yeah, so probate, sort of a fancy word that essentially means prove. So you are applying to have the will proven before the government, so before the probate registrar in BC. And the reason it gets a bad rap is because, I mean, there is a cost, of course, associated. The actual cost associated with applying for a probate grant with the government is fairly nominal. It's not that expensive, but of course, it is a complex process. So typically lawyers are involved. So it drives up the cost. Mind you, getting a grant of administration is not any cheaper. In fact, it's typically more expensive. So the other piece, of course, is that there is a tax. There is a probate tax that comes into play. So all of the assets that are in your estate, say you have $1 million inside of your estate, it's going to flow through and the distribution is being governed by your will. So you're going to take that will, go to the probate registrar, get it validated, which usually takes about 2 to 3 months. And then the registrar is going to say, okay, you've disclosed that, you know, there's $1 million that's going to be flowing through here. It's taxed at 1.4%. So $14,000.
And that's the highest probate rate in British Columbia. Each province has their own rates of probate, I guess you would call them. And BC's is 1.4%, has been for as long as I've been aware of it, for the last 15 years. So that's the most that you would ever pay on as a tax to the asset. So let's just run the math. $1 million, $14,000 is 1.4% of $1 million. Where does that money go?
Well, I mean, that money goes to the government. Okay. So
it's literally a tax to the provincial government.
It's a tax, and I mean, you could call it a fee as well, because of course there are costs associated with staffing the probate registry. And, you know, to be honest, I don't know how the government coffers, or you know, where all that cash lines
if that goes into the general pot, if you will.
Yeah.
So the way that I like to describe a will for people when they're talking about it is it's a document that essentially ensures everything goes to the people who you want it to go to. And the way I like to think about it in relation to probate is you're essentially paying this fee to simplify the process, to make sure that everything goes into one place, and then all of the income taxes and such are paid, and we'll talk about that later on. And then the distribution of the net proceeds is paid out to the people who you want it to get paid out to. And what we're going to talk about later is direct beneficiaries is an option. So what I'm trying to get at is people will go to great lengths, Steve, to avoid probate, and by taking stuff out of the will, right? By having direct beneficiaries on RSPs or TFSAs, or by adding joint owners to real estate or bank accounts. And when that's done, you're essentially opening yourself up to other problems so I'm not saying you can't do that or you shouldn't do that, but we have to be very careful whenever we bypass a will, in my mind, because you do open yourself up to other problems that could present themselves.
Yeah, there's an act in BC called the Wills Variation Act, and that is legislation that governs who can bring a challenge to a will, or who can bring a challenge to a distribution plan. And you know, probate isn't necessarily going to save you from that, because if the will is drafted in a manner that is inequitable, you know, or unjust, unfair, then it can still be challenged. But yeah, what probate does is at least it certifies what the actual distribution scheme is going to be, so that you have a source of truth, you know, incontrovertible truth that the government has endorsed, and so that you have clarity on what the wishes are. So yeah, I mean, that's just it. It's like the will is your clearest, most legally binding expression of what your wishes are going to be, that is going to be going to go to the next generation. So
perfect.
So we have a good question here. If you don't have a will, okay, does the government take a percentage of the estate, so beyond probate? No will.
No, not beyond probate. There is still going to be a fee for a grant of administration. It's going to be the same fee. So you can't like short circuit it in that manner. If you still need to get an estate grant, right? So there's no incentive there to not get a will. But no, I think the question was more like, is the government just going to seize something? In all likelihood, no, unless there are no intestate beneficiaries. So no beneficiaries who have any kind of connection at all to the deceased. And then in that case, yes, there is a possibility.
And just maybe to add to that question to Amanda, maybe I'm reading it the wrong way. Sometimes we get it as well that, you know, what's the estate tax in Canada? And because in the US, of course, there's actually an estate tax.
Yep.
In Canada, there's no estate tax. It's just that the second before you die, everything that you own is deemed to be disposed of, sold. And so in that moment, if you sold everything that you ever had today, you'd obviously trigger a big tax bill. And that's essentially why taxes and death are kind of associated with each other. It is important to note that if you are married, the assets will, Steve, you can correct me if I'm wrong here, but they'll roll over to the spouse, the surviving spouse, tax-free. So it's really the death of the last surviving spouse where the tax bill becomes a big concern.
Yeah, that's correct. That's called a spousal rollover. And absolutely, and just returning to your point about probate tax and the 1.4%, we're not going to get into tax in any great detail here because it's just too deep for the purposes of this webinar. But I will say that there are a lot of tax, like the moment of death, as you said, Mike, is the largest taxable event of anybody's lifetime. Obviously, you have the most amount of wealth at that point, or at least a lot of people do. And yeah, and so
Hopefully.
it's
or hopefully not, right? We get a lot of people who say, I want my last check to bounce. But anyway, yeah, I get it.
Well, absolutely, and like that might be, there might be a lot of really savvy tax planning that can occur in the years leading up, in planning for death.
Yes.
That is much, much more valuable than probate. So, or avoiding probate by use of beneficiary designations or other strategies. So, yeah.
Perfect.
And then one more question on probate: what assets go through probate? So the question here is, does everything go through probate? Is anything omitted? What's a quick synopsis of that? That's
a great question. So real estate goes through it. Unless the real estate is held in joint tenancy. So in the case that a home is held in joint tenancy, then it's going to go to the survivor. So anything else that's joint, for example, bank accounts, same thing. Even cars that are held in joint tenancy, it's going to pass automatically to the survivor, and so it's going to bypass probate. And then registered accounts. So we're talking about RRSPs, RIFs, TFSAs. And also those are going to bypass, and then life insurance is almost always going to bypass as well, unless the life insurance names the estate as a beneficiary. And similarly, pension plans and registered accounts can name the estate as a beneficiary, and in some circumstances that's going to be beneficial. And
we'll talk a little bit more about that. But I think, Steve, maybe I can just chime in, Amanda, for that question. Is the way a good way to think about probate and what's exposed to it is anything that goes through the will be exposed to probate, is my understanding, Steve. So if you have an asset that is not jointly owned or doesn't have a direct beneficiary, and you own it, and it's going to be allocated and distributed as per your will, you're going to pay probate on that.
That's correct. And just like one thing that I come across all the time with my clients is they think that like everything that they need to name everything individually in their will. That's not how it works. Like your will captures everything that you own. Because of course, like you're not going to be updating your will every time you buy a new sofa. So
yeah, the toaster doesn't need to be named in the will.
The toaster doesn't need to be named unless it's a very special toaster.
Right. I was going to say, you might really want that toaster.
There you go. So yeah, I think just quickly here too, children. So yeah, I have 3 kids. And when my wife and I got our will done, we had to decide who was going to be the guardian, like if we both died, which knock on wood, the odds are low, who would look after our 3 kids. And so this is a big decision that new parents have to face, right? So the guardianship is named in the will, correct?
Yeah, that's right. So you designate your guardians in the will, and so of course that's a critical conversation that you want to have ahead of time with whomever that you want to entrust that responsibility to, and ensure that they are financially able to do it, that it fits with their life circumstances. They don't live on the North Pole or something like that. That they want to have kids, etc. And it's also very, very helpful to name an alternate guardian as well, because of course you never know what might happen. So that's very important. And if it's not named, that can be very problematic, because then a court application would need to be made in order to obtain guardianship, and there's all kinds of interactions with the public guardian and trustee, so it can be quite complex and onerous. So Mike, I just wanted to point out, we're at 6:30, and I know we've got a lot of content. So
okay, so let's keep going.
Yeah.
Okay, I'm going to go through here really quick. I promise not to talk too much to each slide here, but essentially direct beneficiaries, a way to bypass probate. So we get this a lot. Essentially, I just want to highlight two cases here. I'm going to keep it as simple as I can. We've omitted real estate. Bob is a widow, so he's the last surviving spouse. He has 3 kids, 6 grandkids. He's got $1 million in his RIF, $180,000 in his TFSA, and $150,000 in his non-registered account, which would trigger a $50,000 capital gain at death. So his question to me was, hey, I want to add my kids as direct beneficiaries. Should I? And my answer to him was, no, you shouldn't. And here's why. Taxes owing would be $505,000. Okay. And the estate proceeds, so 500, all of the money, the $1 million in the RIF and the $180,000 in the TFSA would go to the 3 kids equally. The grandkids were not part of the will, and the kids would get all that money. But then the estate has to pay roughly $500,000 in tax, Steve. And so what would end up having to have happen here is the kids would have to give money back to the estate to pay for the tax bill, because that's who, it's not the kids who owe the tax, it's the estate. And so hopefully the kids are all getting along. Hopefully they know what's happening. Hopefully they're in a good mood when they have to write a check for roughly $150,000 each to kind of go through this. So I would say this is not a good example for direct beneficiaries. And if we go to the next slide, Amanda.
Oops.
Oh, one back. This would be, so Mary, 75, 3 kids. She has a RIF of 150,000, a TFSA of 180,000, and $1 million non-registered account. Here, the taxes owing at death are going to be roughly $104,000. Okay. And the kids are only going to be receiving, the 150 and the 180. So the point is, there's a lot there with the non-registered account to pay the taxes. So this would be a good way for the kids to get something up front, save some money because it happens much quicker with direct beneficiaries than having to go through probate. And it will reduce their probate bill, somewhat. So this certainly would be a case where direct beneficiaries make sense. So the point with these 2 slides is to say, if most of the assets are tied up in registered accounts, direct beneficiaries can be problematic at estate time. If they don't represent the lion's share of the estate, then yeah, we don't need to worry too much about adding direct beneficiaries to those registered accounts. So I just think we get that a lot. I wanted to throw it out there. If anyone has any questions, we're happy to spend more time talking about that towards the end.
Okay.
How did I do there, Amanda? Did I take up too much time there?
No, that was a good summary. That was good, and it leads really well into this next slide of, picking your people, right? There's a lot, Steve, I'm sure obviously, on a will, you got to pick your people. You want to pick the right people, because when we go through this list, looking at the no's. So what would you say in terms of somebody picks an executor who's emotional, very dramatic, lives in Bali on the beach, no income, big rum drinker? Like how does that sit with you as the estate planner?
Yeah. Yeah, not the best.
Yeah,
Steve,
right.
Quickly, what is an executor or an executrix?
Thank you. Yeah. So an executor is the person who's responsible for administering your will. So they're responsible for administering your estate, distributing the proceeds of your estate. It's a complex and it can be a fairly demanding task, and one that can last for 12 months, sometimes even longer than that in complex cases. So you want to name an executor, and an executor is also known as a trustee. So if you see those terms, sometimes they are the same, and sometimes a trustee is just a trustee. But anyway, I digress. But again, an executor, it needs to be somebody who's very detail oriented, and ideally it should be somebody who lives, assuming you're in BC, assuming you're in Vancouver, ideally lives in Vancouver, because they're going to need to have usually in-person interactions with the bank, of course, with the lawyer, with the registrar. So there's a lot of in-person things that happen very bad idea to name somebody who lives in Bali, even if they do have a good income, and don't hit the rum too hard. So
Okay.
you certainly don't want to have anybody who's older than you named as an executor as well, for obvious reasons. You do want to have multiple, you want to have a backup. So you want to name a primary, and usually it's your spouse. But if you don't want that, or if you don't have a spouse, you'd name a trusted sibling or a trusted close friend. And then ideally your backup is somebody who is a generation younger than you as well. So.
And ask them if they want to be the executor, just like you would ask them if they want to look after your kids, if you were to both, right? I mean, yeah.
Yeah, and on that note, generally it is customary, it's normal for some compensation to flow to the executor. For one, of course, just about every will is going to have clauses in it that authorize the executor to pay for legal, accounting, other sort of expenses that are normal. And it's also going to provide for some degree of compensation. And generally that can range from anywhere from 0.5% to all the way up to 5% of the value of the estate. And that would be an exceptionally complex estate, but that's sort of the range. Some people also choose to fix sort of fixed dollar amounts. The way that we always draft them is that that amount scales in time as the years go by.
And then finally too, like if you don't have someone who you're comfortable doing, you could hire a corporation to do this.
Yeah, you can appoint a corporate executor. Of course, there's going to be a fee involved. Generally, there's going to be a setup fee, and then there's going to be a percent of the estate that's going to be due as well. So, but that can be a very good option, particularly where there is family discord or drama, that you've got an impartial third party. So it can be a very appropriate way of doing things. Or if the estate is really complex, if there's a lot of business interests involved, again, a corporate executor can be a really good option.
Perfect. And that fee for a corporate executor, I believe, is between 1% and 2% of the value of the estate-ish. Is that right? Ballpark?
It varies. I've seen it as high as 3%. Yeah.
Okay.
Yeah. So you can, shopping around is not a bad idea. And of course, like, you can get a referral from Mike or I.
Yeah. So if you're skipping down to a guardianship here, a guardian is obviously someone who's looking after the kids. If you have a sibling who lives in another country, hates kids, and is single, obviously not a good choice. Someone who you think would be great, but your spouse thinks would be terrible, obviously not a good choice. And yeah, someone close who shares similar values, has kids, and has agreed to the role, I think is obviously the person you want to choose. Just before we go on to power of attorney and representation agreements, Steve, how often should a will be reviewed, and how often should it be updated?
The rule of thumb is whenever any major life change has occurred. So if you have kids, or if there's been a major change in the nature of the relationship between yourself and one of your kids. So perhaps your child is having problems, or there's a breakdown in the relationship. If there's marriage, divorce, I mean, one thing that you should know is that if a divorce occurs, then it's by default, your spouse is not going to be included in the distribution of your estate, even if the will specifies to the contrary. But nonetheless, like, personally, that would make me feel very nervous, even if there is like a statutory, a legal safeguard there. So I would still want to have the will changed, of course, there as well. And any time that there's a big change in the financial circumstances, in your financial circumstances. Yeah,
and I guess too, like the one thing that we didn't cover here, I guess if you no longer want the executor to be the executor, the guardian to be the guardian, you got to change the will.
Thank you. Yeah, absolutely. Yeah, if the executor changes, then it needs to change as well. We just had a quick question in the chat. It was about offshore assets. So I'm really glad that came up. So wills in BC, they govern assets in BC. So if you want to use your BC will in another jurisdiction within Canada, that's a possibility, but it needs to be converted, and it's a bit of a process, and you're going to need to engage another lawyer to do that. So it's actually simpler. Say you own property here and you own a vacation property over in Ontario. Better to have two wills. So to have a will that governs the assets in BC, and to have a will that governs the assets in Ontario. So And similar, and yeah, absolutely, when it comes to offshore stuff, then you must consult with an attorney, with a lawyer in that jurisdiction.
Okay, so if clients came to you to do their will and they had a property in Turks and Caicos, you would want to dig deeper into that and have someone else down there create a will in the Turks and Caicos, or just speak to you about?
Yeah.
Okay.
It varies, of course. Like
Right.
some jurisdictions don't even use wills, but yeah, it's a complex thing that would just need to be looked at very carefully. Yeah.
Okay, thank you. Great question, Kevin. Thank you for that.
So yeah, just jumping into power of attorney really quickly. So a power of attorney is basically a document that governs legal and financial decisions, generally when you're incapable. You can grant a power of attorney, just like it seems like the son is asking for the dad. While the dad is still capable, and then the son could go take that power of attorney and withdraw all the money from his bank account. Be really nice. But generally, yeah, they're called an enduring power of attorney. It endures because the reason it's called enduring is because it endures after you become mentally incapable or physically incapable of doing things on your own. You can specify how that is determined inside of your power of attorney if you'd like to have the authorization of like 2 medical doctors or something of that nature. But generally how it's done is just one doctor will certify that you're not capable, and then the power of attorney comes into effect. So again, you want to name somebody obviously that you trust, because it has been referred to as a license to steal. So certainly you do not want to grant a power of attorney to anybody that you have any kind of issues with. It's generally granted to a spouse and to another person as a backup, a trusted sibling or friend.
And sorry, just to get this straight, so in a standard case, if there is a standard case, someone who has a power of attorney that they have, like they've created a power of attorney and named someone to do it, to act on their behalf. If that person was totally fine, so the person who has the document that they created for themselves, could the person who is the power of attorney actually act on their behalf even if they're okay?
No.
Okay, so that's the standard cases. Okay, gotcha.
Yeah, that's the standard case, and you can also revoke it at any time. Yeah.
Okay.
Yeah, of course you can't revoke anything when you're no longer mentally capable, though. So.
Right. Got it.
Yeah. Representation agreements. So representation agreement, it's also known as a power of attorney for healthcare in other provinces, but in BC we call them representation agreements. And it is what it is. It's to govern healthcare decisions. So it basically authorizes another person to make decisions on your behalf when you are incapable of doing so on your own, with respect to doctors and healthcare. Yeah.
Perfect. We got a few questions that have come in here, Amanda. Do we want to get to them now, or do we want to get to them later?
Yeah, there's been a few.
I think there's just one about.
Okay. They've all
Are you
been
suggesting offshore assets for offshore assets in an offshore will? Seashore by the seashell.
I think it's
something.
Need to be registered essentially in the location that you're doing the will.
Yeah, that's correct. Yeah. And is a clearance certificate required? Yes, a clearance certificate is always going to be required. So when you're distributing assets, so this is part of the probate process, estate grant process. And a clearance certificate essentially is the CRA's certification that no further taxes are owed, and that the estate can distribute the remaining assets to the beneficiaries. The state gets paid first is the point there.
Got it.
Yeah. Perfect.
The CRA gets paid first.
Yeah. Yeah.
You got you. Okay. Yeah, they do. That's for sure. You don't want to be in debt to the CRA. It's not a good scene. So we got to make sure that they are looked after.
Yeah.
Awesome. Okay, we are going to move into some family drama. Everybody's favorite.
I just want to clarify one thing. Ryan chimed in. So once a person becomes incapable, control moves to the executor, not the executor. It's actually the person with the power of attorney has the power. I mean, the right to steal. it's not the right to steal. It's like it's called a license to steal. It's not, it's a joke, you know, it's not actually, of course, that's the risk though, that I'm trying to alert you to, is that you need to have somebody that you trust. So you wouldn't want to grant a power of attorney to anybody that you have any kind of trust issues with. Yeah.
Yeah, and I would imagine that there's laws governing the fact that if a power of attorney did go rogue and did things that were clearly not in the person's best interest, that there'd be recourse that the family could take on that. So, but certainly.
Sometimes, but it's kind of a hard case to press, you know, because if the person that says, well, this is what they, anyways, yeah.
Choose the right person.
Choose carefully. Yeah. Okay, so inheritance and gifting, the drama. I love the title. So problem children, addiction, and other considerations, disinheritance. So yeah, of course there, you know, heaven forbid, but obviously there are scenarios where parents may wish to structure an inequitable distribution of their assets, where one child is getting more than the other, or one child is not getting anything at all. That may be because of addiction, because of an estrangement, whatever the circumstance that is, whatever the reason is for that, it's a scenario that needs to be handled extremely carefully, because under the Wills and Estates and the Succession Act, there are clear guidelines that basically specify that the spouse and the children need to be treated fairly and equitably. So one of the ways of going about that is available to persons, only to persons who are over 65 years of age, is an alter ego or joint partner trust. In the case of a joint partner trust, only one of the partners needs to be over 65. But those trusts are basically ways that you can transfer your existing assets, be it company shares, real estate, Parrs, bank accounts, etc., into the alter ego or joint partner trust. And then, and you appoint a trustee, which is generally going to be yourself, and then one other person to manage the trust. And then all the assets are in there. So that's a mechanism for avoiding a wills variation claim, because when it comes time to actually go through probate and to actually probate the will, then there may not actually be much left in the estate, if anything at all. This is very
it's all gone. It's all in the trust.
Yeah, it is very tricky stuff though, and does need to be handled quite carefully. There's big tax implications, and in particular, it's quite complex to have real estate in there as well, because the actual ownership may not necessarily change with the land title office when you are transferring the real estate into the trusts. But that's kind of getting into the weeds.
Yeah, we want to kind of stay out of the weeds if we can. I just think it's important for people to note that like you said, whenever these scenarios come up, we've seen them before. It's incredibly like a lot of money can go to no one because it's being battled over in court. And there are lawyers in town that I know personally that specialize in fighting for those black sheep, if you call them black sheep. And it's just not a pretty process. And I think one way to avoid the drama, I mean, Steve, to do your best to avoid it, is to also open the lines of communication, I mean, as much as possible in advance of all of this, right? When everyone is of sound mind, when everyone is not running high on emotions, when there's not millions of dollars on the table, is to communicate as much as possible within the family to make sure everyone knows what's going on. And then the process seems to go a lot smoother when everyone knows what to expect.
Yeah, no, I absolutely agree. Yeah.
A big one we've seen during COVID is this making gifts during your lifetime, early inheritance. This has been really big the last couple years, namely in the form of real estate, which we'll touch on in a minute here. But let's say from a non-real estate perspective, what are the implications? What's the smoothest way that you see this done, Steve?
So making a gift during your lifetime to a child can be called an advancement. So it's an advancement on inheritance. And so again, like if you give $1 million to your kid, and then there's only there's $1 million left in your estate, and then you have two kids, it's been divided 50-50, say there's no spouse involved, so $500,000 each. But the one kid is like, well, you got twice as much as I did, or 3 times as much as I did rather. Then you may have an estate litigation matter on your hands, notwithstanding that the gift was made during the lifetime, because it could still be deemed to have been a part of the estate. So again, you want to document that very carefully and consult with a lawyer if you are going to be making a gift that is going to put one of the other children into an inequitable position.
Yeah, and I will say, Amanda, I'll just jump in here quickly. We have a philosophy, Steve, I don't think I've filled you in on it, is that measured generosity is sustainable. It's a bit controversial when you could have a whole dinner conversation around measured generosity is sustainable. The point that I'm coming from is not from an estate planning perspective now, but just making sure that the person making the gift is okay. We get a lot of clients who are exploring gifting money to kids to get into a real estate market that is clearly challenging to get into right now. And we support that 100%, but it's got to be done in a way that the person knows what to expect after they've made the gift. So can they live the retirement lifestyle they want? Can they equalize the estate with the other 3 kids that already are in the real estate market? It's a very, very, it's a decision that you can't reverse. So you want to make it very, very carefully. You want to be very measured. So yeah, happy to chat about that after the fact if anyone has questions there as well.
Yeah, and we have a worst case question here. So what happens if both parents with underage kids pass at the same time? So example, hit by a bus during an active legal dispute with the CRA, how would the case proceed?
I mean, the CRA is going to come after the estate for whatever it is that they are after.
And yeah. Well, I was just thinking, like, I mean, this is a down the weeds question, so we can dig into it one-on-one after the fact with the individual. But I guess like maybe there's 2 estates as well, right? There's if they're now divorced, I think was where they were going there with that question. But that's a very detailed question, I think, Steve, that we'd have to dig into the circumstances on.
Yeah, I mean, the short answer is it would go to litigation. The estate would have to hire a lawyer to carry on the battle, really, and it really just very much depends on how much cash is involved. So what happens if the trustee takes longer to execute the will than the time specified in the will because the clearance certificate takes a long time to obtain? Is the execution period extendable? So generally, if the trustee, aka I think the executor in this case, there's not a timeline specified in a will. I've never seen that in any kind of will, that it must be done within a certain period of time. And I would strongly recommend against it. I don't even know if that's legal. I haven't seen that before. And the reason for that, of course, is that there can be unexpected complications that arise during the administration of an estate, and it can take anywhere from 4 months to years. So,
okay. So, kind of going back to that gifts during your lifetime. Now, we were chatting before the webinar, and I've actually had this, I think, 3 times in the last 2 weeks, where I've seen with clients of ours talking about real estate and joint ownership, where we have a parent who is looking to purchase with a child, always one of multiple children, never a single child, which makes it more complicated. And again, we don't need to get into the weeds on it, but it is something that we're coming across more and more frequently. So when we're looking at real estate, when we're looking at gifting and joint ownership, what are the implications there?
Yeah, so with joint ownership, so say when you are adding somebody as a joint tenant, a joint owner of a property, then the first thing, of course, is that there's a taxable event. So a capital gain is going to be triggered at that moment. And so that's the first consideration. The second consideration is that it may mess with the principal residence exemption. So the principal residence exemption is one of the most important tax benefits that a Canadian individual has available to them. So you want to be very careful with that. Of course, if it's like an investment property or the family cottage, then that might not be as relevant. Another point that I want to raise about this is there's an important distinction between joint tenancy and tenants in common. So joint tenancy, also known as just joint, is when two or more persons each own an undivided whole interest in the home. So meaning that if one of them were to die and there's one person left who's also joint owner, then they inherit, they get the whole thing. So they're the survivor, they have a right of survivorship, so they get it. Tenants in common is very different. Tenants in common is very much like splitting the pie into 4 slices, and you've got 4 tenants in common. Sorry, my power just went out, but I think we're all still here.
You're still here.
Good, yeah.
You're good.
Yeah. So yeah, tenants in common. So that then they're wholly separate interests. So if one person were to say, Mike, Amanda, and I, we all got a place together, we're tenants in common, and then I were to die, Mike and Amanda would not get my place. It would go directly through my estate. So it would go to
whoever you named in the will,
essentially.
Yeah, and we see a lot of joint ownership more, I think, than tenants in common. I think, but at the end of the day, like tenants in common, there is a time and a place for it. Makes a ton of sense in a lot of ways at the right time. And I'll just say from a gifting perspective too, yeah, I mean, this goes back to making sure that the person who is gifting can afford it from a financial and retirement perspective. I will also say that, you know, trying to avoid, let's say that you bring on joint owners to make the $3 million home in Vancouver not go through the will, and you bypass probate and you save 14,000 times 3. It's getting late in the day for math like that off the cuff, but you can open a whole new can of worms, a whole new problem set by doing that. Because if you're going to live for another 20 years and you now have all 3 kids on as joint owners and one of their marriages break down, that asset is up for grabs. You no longer control that asset. Like if we just take for granted, I think that sometimes that the family is going to stick together and be fabulous all the way through life. If that were to change, you can cause problems. If that person who is a joint owner in the house runs into financial difficulties, then that house is up for grabs from a bankruptcy standpoint. So again, like, certainly there's a time and a place for it. Just be very, very careful with how you proceed. Talk to a lawyer, talk to us about if it makes sense. And then of course the decision is ultimately yours. It's just really good to think long and hard about this, as opposed to just randomly, you know, adding people as joint owners, even on bank accounts, same thing.
Yep. And then what's the difference between that and a direct beneficiary for a real estate? So Mike, you wanted to bring in the direct beneficiaries example.
Oh no, sorry, Amanda. Yeah, I was just referring to adding a joint owner onto the property, which is effectively the same as making them a direct beneficiary on a registered account. So that was a miscue between you and I. But yeah, know that you cannot add direct beneficiaries, Steve, as far as I know.
No, but it's a good analogy. Yeah, as you point out. Yeah.
Okay.
Thomas has just mentioned if the recording is going to be available for later viewing, and I think we've got.
Just reach out to Amanda.
You need to let me know that you'd like the recording so that I can add you to the list and make sure it doesn't get sent out automatically. Okay, so our last topic here before we get into some more questions, let's get corporate. So let's talk about corporations.
I'm gonna just really buzz through this because I know we're kind of tight on time here. So the importance of a shareholder agreement. So the reason we're talking about shareholder agreements inside of an estate planning context is because they really go hand in hand with will. It's the shareholder agreement is really going to govern what's going to happen to the business in the event, of course, if we'll speak to death here in case one of the principal shareholders were to die. Generally, the scenario that unfolds there is you say you have 2 shareholders who each own 50% of a company. What the most prudent way to handle it is, say the company's worth $2 million, and such that each shareholders, their shares are worth $1 million, is to have a life insurance policy on the name of each shareholder that is owned by the corporation. And then the shareholders agreement is going to govern how those funds are flowed through. So it's going to generate what's called the capital dividend account benefit, which is a very good thing because it means that that cash can be flowed through directly to the shareholder and tax-free. So it's a great way of doing things. And it ensures that the company is going to survive and that the estate of the deceased is going to have cash on hand without having to imperil the business. Because the alternative, of course, is that the person, the deceased dies, and then the estate becomes effectively a shareholder in the company, doesn't have any cash, and could mess up the business as well.
And you're doing
Mike,
business with
on?
someone
Like
who I am
red in the
smiling.
face.
It's like, you know, you end up putting yourself in a situation where you're in business with someone who you shouldn't be in business with. And so that life insurance thing is great. I will add from a tax perspective, again, this is complicated, but in 2016, 2017, the tax laws changed with regards to life insurance. So the capital dividend account is still massive. It's a big win, but on permanent life insurance contracts, there can be some tax payable. It might not all flow through the capital dividend account. It's harder for that to happen now than it was pre 2016. But anyway, it's a huge win for sure.
Yeah. So with respect to how company shares are dealt with, generally they're an asset like any other. So they're going to flow through the estate. So, unless there's a shareholders agreement in place whereby the company is going to purchase the share in exchange for the proceeds that flow from the insurance policy, then they're just going to flow through the estate. So one item here that I wanted to mention is called a corporate will. So this is basically where you have a normal will that's going to govern all your normal personal assets, and then a secondary will called the corporate will that just governs things that do not need to be probated. So some items do not need to go through probate. So real estate always needs to go through probate. Otherwise, the land title office is not going to recognize the transfer of the real estate. But shares, that's not the case. So in a circumstance where you have shares that are worth a huge amount of money, say they're worth $10 million, there's also a significant tax benefit, of course, to be realized there. $140,000 would be the 1.4% that you would pay on probate tax. So it makes sense to put the shares of that private company into a corporate will because the planning costs on the legal and tax side are going to be nominal compared to the gain.
I feel like too, Steve, whenever a business is involved, the complexity of the situation increases several notches. And I mean, if we just think about the small business capital gains exemption, and I know that there's ways that you can actually still, even after the new rules in 2017, kind of, I don't want to say extend that, but sort of, have more people participate in that, which is a $850,000 capital gains exemption. So if you own shares in a small business and you sell it or you die with those, then that's tax free, right? So it's so worth investing some time and money into making sure that this is all done properly, because the amount of money that you can save in the end is great. But also, even from a shareholders agreement perspective, like, it doesn't have to be death. It could be disability, a disagreement. This is a really important document that and your team can help with this. I mean, this is what you guys do, so it's great.
Yeah, we do this all day long, and we do dispute resolution as well. So I deal with the scenarios where people do not have these agreements in place, and I can tell you it's not fun. It's not cheap, and it takes a real long time. So it's essential that any successful business that has more than one shareholder absolutely needs a shareholder agreement. I can't really impress this enough. Like, it's just so important. And it's way more overlooked than a will. At least there's some degree of public education around wills, but there's very little awareness around shareholders agreements. And frankly, they're complex documents, and it's important to deal with somebody that you feel comfortable with. And they also interplay quite a bit with your financial advisor, and with your accounting team. So they're complex, and you need a bit of a village to get you across the finish line. But yeah, I really can't emphasize how important it is. And yeah. So
I don't know if this has happened to you, but I've asked business owners about, to see a copy of their shareholders agreement, and they're like, so and they have one, right? So it's funny how these things kind of, they get done and then they get filed or saved or whatever they do now. And yeah, so important to keep that stuff up to speed. So it's not a problem until it is one, of course, and then it's too late. So important to keep that stuff up to speed.
Thanks. So we've got a question here. This is the last slide. This is our Q&A. So if you have something else, please add it in. Question here is, if you add other names to your home title as joint owners, what tax is payable? What tax is payable if you, original single owner, then pass, then die?
Well,
can you ask that one more time?
So if you add other names to your home, right, as joint owners, what is the tax payable once you, the original homeowner, pass?
You go first, Steve.
Oh, I was going to say, I mean, it depends, right? I mean, it depends whether it's a principal residence or not. And
I think we would assume principal residence here.
So if you add somebody to on title, then there's going to be the capital gain is going to be payable. So
yeah, so my understanding of the question is, you've got this property, someone owns it, you want to bypass probate, or you want to do something funky, you bring on joint owners onto the property. If that is not your principal residence, there is a capital gain for the portion that you are essentially gifting to these other owners. So the CRA does not care that you are giving this property to your kids at fair. They're going to assume that you've been paid to do it at fair market value. And if you don't claim that you've done that and get audited, you will absolutely have to pay taxes on that portion. But the interesting thing here is that there's no money been exchanged. So do they have the $200,000 in taxes that they owe, $200,000 in cash that they owe in taxes? And if it's a principal residence, Steve, I think like there won't be a tax then. But certainly if the new joint owners, if it's not their principal residence, then
assume that it then is, right? So assume that it's, so Mike, you decide you're the original single homeowner, your 3 kids, you're now adding them on to your residence. They're all renting, right? So now everybody's in the house again and you're all on title.
And we're all living together. Well, I mean, I guess yeah.
Worst nightmare for you. You're like, they left.
We're in the business of dreamscaping, not nightmarescaping. I love my children; they're fabulous. But yeah, that is an interesting question, because it's not a sustainable long-term solution, right? At some point, those kids are hopefully going to buy a house, and then you can't have 2 principal residences at the same time. And so yeah, I'd have to sit down and have a conversation with this person about that. Steve, I think you probably want to say the same thing.
Yeah, I totally. I mean, that's pretty involved, and yeah, I actually don't know if children and parents can both claim principal residence if they're on title. I've never come across that, and I don't know if that's a thing that is even that works.
Yeah, I think yeah, that's an interesting point. But yeah, that's one we'd have to dig a little deeper on.
And I think ultimately you don't want to make things more complicated than they need to be when it comes to this stuff, right? Keeping it simple, keeping it within the constraints, working with a team that can help guide on the best option is definitely the number one here. We're not trying to make situations more complicated than they need to be.
Yeah.
So Len, I speak with an accountant is the short answer. Like, speak with a tax advisor on this.
Yeah, and Len, if you want to chat too about that, certainly we can have a call. We can schedule some time and dig into it. I would think too, that anyway, I gotta wrap my head around it. So I don't want to go off the cuff without all the information, but interesting. Thank you.
A great question, and thank you for bringing it to the table.
For sure. You stumped us. There you
Yeah,
go.
right at the end too, right at the end. We're on a roll. But yeah, so I want to thank, there doesn't seem to be any more questions, but I'm going to ramble for 30 seconds in case there is and somebody wants to throw one in. I want to say thank you to everybody for joining. Huge thank you to Steve and Parr Business Law. These expert series webinars are massive for us. The ability to collaborate with experts and get them to talk to our clients and speak to your clients and your network as well is an incredible opportunity, and we really appreciate it. That goes back to our values of freedom, family, and performance, and being able to provide this. So thank you very much. I rambled and there's no more questions, so I think
awesome.
that's it.
I'll just say too, like for those of you who listened in today who are not part of the Hillside family, so this is the first time you've been exposed to Hillside, please visit our website and sign up for our newsletter if you'd like to learn more. We'd be happy to send you a letter. We write it from at Hillside personally. We send it out 10 letters a year. We speak from the heart, and if there's ever been a time to definitely know you know, how your money is being managed and how your retirement is being planned, now is definitely the time. So certainly a good time to dig up and learn more information. These series too, I want to say, are all about education. We want to make sure that you get everything that you can out of these, and then you take the information and apply it to your situation, or at least you know, use that as the first step to you know, really addressing the situation properly. So thank you all very, very much for coming. Steve, pleasure to have you. That was fun.
There is a quick survey as you guys jump off. There will be a quick survey that helps us gather some information. If you want to chat with Steve, if you want to chat with us, please put that. There's a box in the survey for that. And if there's any other webinars you'd like to see, that's a question in there as well. So if you get a chance to fill that out, fantastic. And if not, I hope everybody has a fantastic evening.
It is a beautiful one out there. Thanks, guys. Take care.
Awesome.
Thanks, everybody.
Thank you.